Okay, this is People of the State of Michigan versus Derek Earls, docket number 20-182 FC. And this is the time set for hearing on the defendant's motion to lower bond. And Mr. Earls is present with counsel, Mr. Manaloni, Ms. Eisenhut for the people. Go ahead, Mr. Manaloni.
Judge, I had an opportunity to review the bond report, and I am asking the court to consider lowering Mr. excuse me, Mr. Earl's bond to 50,000, 10%, or a 50,000 cash surety.
Right.
I think the bond report covered all the essential elements of whether he would appear or not from the area and all that. So, if the court would rely on that rather than me going through it all, I would prefer to do that unless you want me to go through it.
All right, thank you. I did read everything, so I'll turn to you then, Ms. Eisenhut, if you have anything to say in reply. I can't hear you, Ms. Eisenhut.
Nate, you're going to be over here.
I can't hear you.
Nope.
Say something again. No. No. It looks like maybe she disconnected and she'll call back in.
Okay. Had problems in Sanilac County this morning too. I don't know, maybe it's the weather.
Yeah, I was talking to a Wayne County judge and they lost power and water and everything happened this morning.
Are you serious? Wow, it never ends down there.
I know.
Judge, I'm hoping that you fixed it.
We can hear you.
Okay, wonderful. Thank you. I'm sorry about that. It's been a minute since I connected to the work computer, so some technical difficulties. Just a couple of points briefly, Your Honor. In examining the factors set out under Michigan Court Rule 6.106, this is 9 counts, all of sexual abuse against 2 minor victims under the age of 13, one of which this individual threatened to snap his neck if he ever disclosed the abuse. It happened over a period of 3 years. It's a violent case, and the behavior, quite frankly, is predatory as well. It's the people's position that the bond is appropriate as it's been set. While we ultimately agree with pretrial services conclusion that a PR bond is not appropriate, I disagree with counsel in that this particular report shed much light on the issue that the people raised regarding Mr. Earl's, ties to the community and being a flight risk. While the conclusion is that he is not a flight risk, none of the addresses or community ties have been verified per the report. In addition, Your Honor, there has been no indicated change from the last time that we had addressed this bond. There is a trial date that is currently pending for next month. So therefore, the people would ask that the bond remain where it is.
Yes, I think I've even gone through this before, but the bond set right now it's really not grossly unreasonable considering the severity of the charges, criminal sexual conduct charges involving minor children, alleged threat to do physical harm to one of them, looking at a possible mandatory minimum of 25 years. I do note and regret that we're coming up, I believe, on 1 year that Mr. Earls has been in jail. However, that's through no one's lack of diligence or wanting to get him to trial. And I am hopeful that our current suspension of jury trials order ends on February 1st, and we have noticed this case for trial on February 1st it's looking to me like it could very well be the number one case to go on that day. And I'm feeling a little more hopeful that we actually could resume jury trials on that date with the numbers really sort of plummeting downward recently. But of course, that still remains to be seen. But I'm hopeful. So considering all the factors of the risk of flight and dangerousness to the community, I am denying the defendant's motion to lower bond. Oh, I would add too that he had a very sketchy address. He was homeless, he said, and then he said he was living with his brother. There was no long established verifiable address, even though he reported he'd been an Ingham County resident for all of his life. And the address of his brother that he gave couldn't even be verified. So the report wasn't extremely positive in making any change in the bond. And again, I'm denying the motion.
Judge, are you still doing half-day trials like you did before if they start again on February 1st?
No, I have a schedule. I thought I sent it out to everybody, but I'll double check that and send it out to you again. I made it mostly full days
Okay.
in order to, shorten the number of days that jurors would be coming in and out of the courthouse.
Okay, because I have a whole day is filled for me only because I didn't know with these numbers if they're gonna, if the trial goes, obviously those things all have to be moved. I'm just hopeful of knowing before the 1st, so that way I can make sure everybody knows what's going on. And I wasn't gonna move my afternoon stuff if you were gonna do stuff in the afternoon, but I get what you're gonna do all day trials now. Okay.
Somewhere I wrote a schedule down. I will send it to you as soon as I get done with my matters this afternoon. I'll send you both attorneys the trial schedule.
All right, thank you, I appreciate it.
Sure, you're welcome. And
All right.
Mr. Earls, you can tell them they're at the jail that you're all done then.
Okay.
Thank you.
I'm all